Hi, this is Keith Pabian from Pabian Law. Today we're going to discuss something that's a big part of the H-2B seasonal visa petition process, but it's a part of the process that sometimes flies under the radar, and that's the Prevailing Wage Determination application. So this thing is important for a few different reasons. One is understanding what it is, the second is understanding the legal requirement, and the third thing is why it's so important in terms of timing for the success of the actual application. So let's first start with what this thing is, okay? So what the prevailing wage is it's the U.S. Department of Labor's view of what people need to be paid minimally to do the job that the employer is sponsoring them to do. So let's say that we're talking about a resort in Burlington, Vermont, just randomly picking a place. If that resort wants to file for housekeepers, the government wants to see that the housekeepers are being paid a certain wage, which is minimally the prevailing wage, okay? So here's how this thing is calculated, and then I'm gonna explain how it works. Basically, every year, the U.S. Department of Labor surveys employers. They send out surveys. The employers then hopefully return those surveys with wage information of what they're actually paying their workers. And based on that, the U.S. Department of Labor puts out these prevailing wages. What they do is they have different buckets of jobs. So they always analogize your job as an employer to their buckets, whether that's a server captain, a dining room manager, and so on. And they analogize your positions into these buckets. And when they do these wage surveys, they figure out what are the wages that should be calculated for each of those buckets, okay? What you'll notice is the wages are always a year behind, and it's always going to be skewed towards which employers get those surveys. But one of the big things that I want to point out here is the prevailing wage is calculated locally. It's not done nationally. So each area, each town, each county is going to have a different prevailing wage for the different roles. And hopefully, they're pretty accurate with what you feel like the wages should be in your market, okay? Second thing is, so that's how they're done. Now, in terms of the legal requirements, what the law says is that employers have to pay the higher of the prevailing wage or the actual wage. So let's say that resort in Burlington, Vermont is paying their bartenders $20 an hour, but the U.S. Department of Labor issues a prevailing wage of $15 an hour. What the law says is that all of those H-2B bartenders, as well as all of the Americans, need to minimally be paid $20 an hour because that's the actual wage. Conversely, if everyone is paid $13 an hour, the prevailing wage comes back at $15. The only way to move forward with the H-2B visa petition is to bump everybody in that role up to $15. So one of the things that we sometimes see, most of our clients thankfully already pay at or above what the government thinks they should, but sometimes we actually see Americans get a pay bump as a result of the H-2B visa process. One of these side benefits of the H-2B visa petition process. All right, now last thing is, why is this thing so important? And the reason is it's the law. So, and it's also a huge piece of the H-2B visa petition process. So when we start the process, once we figure out what jobs and our clients are doing and what their job descriptions are, we need to file for the prevailing wage application. What's weird about the process is we can actually look up what the prevailing wages should be online, but we have to wait for the U.S. Department of Labor to issue them. And sometimes the Department of Labor issues wages that either we think are incorrect or maybe it was borderline and the wages come back with a little bit of a surprise. Most of the time we're able to accurately predict them. But the big thing here is we cannot file the next step of the application, the big application with the U.S. Department of Labor, which is required to be filed 90 to 75 days before an employer's start date. We can't file that biggest part of the application unless we have the prevailing wage determination back from the U.S. Department of Labor, meaning that it is an integral step in the process where we can't move forward unless we have it back. And so this is where I always talk about why deadlines and starting early is so important, and that's why we start H-2B petitions 6.5 months before employers actually need the workers. So that's the prevailing wage. I know it's something that oftentimes flies under the radar. Some employers think that it's based on national wage data rather than local, but hopefully this video has been helpful in debunking some of those misunderstandings and also just providing a little bit more context and insight into a really important step in the H-2B visa petition process. So as always, we're here with any questions. You can find our contact information at pabianlaw.com. And I thank you all so much. Have a great day and take care, everyone.